All right, welcome back. This is Registered Trademarks Part 3, and we're in the textbook at all the pages I wrote there, essentially in the syllabus, everything that comes after page 468. And as you'll see, we won't cover everything that's in those pages in great depth. A lot of it I just put there for illustrative purposes. If we don't cover it here, it's probably not something that you have to remember, but still good to know to have some context about the regime, right? So, bunch of issues that are addressed in those pages very summarily, as you'll see, right? And most of these issues we actually discussed mainly in the first capsule. So, we won't repeat them again in great depth to the extent that we covered them already. So, first issue is registration. What is the process of registering a trademark, right? And as we said, right, this is covered under the Trademarks Act, which is a special procedure whereby the government is going to look at what you're claiming and check if it's true, right? Check if you do meet the statutory requirements in the Trademarks Act. And then you'll have an opposition procedure whereby people are going to be able to come in and say, this is not legit, it shouldn't be registered. And since we're, as I said earlier, under registered trademarks, right, main issue is going to be whether your trademark that you're attempting to register is confusing with, right, or otherwise infringes upon another registered trademark, right? So a trademark that is already registered, and if it does, that will prevent you from registering your trademark. You still have to meet the conditions that we discussed before, right? It has to be used, it has to be distinctive, but again, the main condition most often to bar registration, to prevent it in the first place, is when the trademark is confusing. Sorry about that. Siri's not sure what we're saying. So the main issue is whether your trademark is going to be confusing with an existing trademark that is in the registry, right? And this is covered by a number of sections of the Trademarks Act, generally at the end, right, around the 45 to perhaps 65 or 70, right? And as a general rule, who has entitlement to registration, assuming that there are two potentially conflicting trademarks. So again, that's a different scenario, right? This is not where I'm coming in after someone's already registered their trademark. In that case, it's simple. You have to look at whether my trademark, right, infringes upon another one, right, is too similar or confusing or perhaps, makes a use of a part of another trademark that is forbidden under the regime. So in that case, right, to kind of hammer this home, it doesn't matter whether the trademark I'm registering second, at least for our purposes it doesn't matter. It doesn't matter if the trademark I'm registering second is better, more distinctive, right, has a longer history, has been around for longer, was first used in Canada. Generally that doesn't matter. What matters is when you come in to register a trademark, right, you compare it with whatever is already in the registry. Even if it's, trademarks from companies that don't have as much of a history or are not as distinctive. Of course, if these trademarks were, improperly registered in the first place, right, so if when they were registered they did not meet the conditions, you can have them removed and then put in your own, right? But barring that, it doesn't matter which one's older or better. What matters is you're coming in second, so you're being compared, rightly or wrongly, with whatever is already in the registry. What if we have two trademarks that come in and neither is registered? In that case, right, very rare case where they might be conflicting and are not already registered, the first to use in Canada is entitled to registration. So the earlier entity, person, company, whatever it is, that used their trademark in Canada, this is important, in Canada is entitled to registration. That's as much as you need to know, right? And we won't look at that in great detail, but the in Canada part is actually pretty relevant for the entire trademark regime. So when you claim distinctiveness, and again, this is not going to be on the exam, when you claim distinctiveness, right, it has to be in Canada. It doesn't matter that all Europeans know that your chocolate bar looks the way it is and buy it for that reason. That's relevant, right, but not determinative. What is determinative, you know, it might be proof that people know it in Canada, but what is determinative is whether people know it in Canada. Distinctiveness in Canada, reputation in Canada, goodwill in Canada, and again, in the case of two potentially conflicting trademarks that have yet to be registered, what matters is the first to have been used in Canada. So, Section 30 tells you what you have to put in your registration, right? And essentially, very similar to what we saw under copyright. You know, the name, the thing, under industrial designs as well, right? We didn't look at the copyright regime in terms of registration in great depth, but we mentioned it. And then we looked at industrial designs, which, as we said, have to be registered. It's mandatory. And we said, right, there's the name of the person who made it, there's a title, there's a description, there's a picture of it. The usual things, right, that you think are necessary to know what it is, right, and to know who owns it. And generally, that's the person who made it, barring, you know, further transfer, assignment, or, you know, any of the other things that you can do with your rights once you have acquired them under the regime, as we said multiple times. So, what are the requirements? Well, the application has to include, the main ones are, right, the mark for which the registration is sought. So, you know, generally a picture, or at least a description of it, right? So a picture of your packaging, your logo, whatever your distinctive element is, right? Then you'll need the specific goods or services that will be associated with. That's important because, as we said, you might have a legitimate trademark on a word or a logo, but that doesn't mean that it covers its use on any product. In fact, it doesn't, right? As we said, use limits what you're protected for. So if you make t-shirts, you're protected only for t-shirts, or things that are similar enough as to induce confusion. And so in your application, you're going to describe, and generally you can't describe it in extremely broad terms for the reasons I just said, you're going to describe what it is that you're going to use your trademark on. And that's the second thing, right? Then you'll have the date of first use of the mark. Because as we said, in the case of conflicting trademarks that are being registered, we're going to look at the first use in Canada, and so it's mentioned on your application. The Trademarks Act was amended, as they say in the book, which is something you don't have to worry about a lot, to remove the requirement of use. But that's not really true, right? What they did is they removed the requirement of use, right? And so you can get registration without a statement of that. But then, you know, they added later on to the expungement or the other opposition procedures after you're registered that someone can come in and say, you never used it or you never intended to use it. And so essentially they're going to nullify the registration, which really adds the requirement but in a different way, right? It adds it kind of retroactively as opposed to, you know, as a condition of registration. So for our purposes, you can assume that the date of first use in Canada is relevant in process that grants you a trademark or registration over a trademark, and also relevant in establishing, as I said a few times already, on two potentially conflicting marks. They're being registered at the same time, or, you know, around the same time before one of them gets, you know, official registration. What's going to matter is the date of first use in Canada. And, right, there's other sections, as you're told, that give the government the power to basically change the rules, right? To ask for more information for certain types of marks, usually marks that are harder to assess, like sounds, right? You might know the MGM lion sound that we see at the beginning of movies. That's probably the only one that everyone would know, and so registrar might find it hard to assess distinctiveness and can ask for further information to establish that, especially in the case of certain types of marks, right? Certain types of distinctive, the characteristics, right, that are needed for the registrar to evaluate the application. So, under section 37, right, you don't have to remember all the sections. Generally, they're just for reference purposes. The more important ones are obviously the definitions and the tests for infringement and so forth, because they're generally set out in the law. But you don't have to remember the number of the sections, right? Just what the most important ones say. So under section 37, the government, as I said, conducts an initial review of what you said to see if it meets the statutory conditions. And the government applies section 30, which we saw earlier, which says basically that a mark cannot be registered if it's confusing with one that is already registered, or if it doesn't meet the other conditions. Just common sense. The government assesses whether you are, whether what you asserted is true, and then whether what you asserted grants you a right to registration under the regime in that you meet the various conditions that apply. Then, as we said, right, there's this opposition procedure under section 38, right? And so that's an important characteristic, right? I won't repeat what it's for because I've said it twice already, but essentially what it does is it's helpful because interested parties have an opportunity to come in and say, this is not legit, doesn't meet the condition, don't put it on the registry. And therefore, later on, even though that's not a full bar, right? I said bulletproof, it's not a full bar to further, contestation of the registration. It helps because it is some helpful evidence that people did not oppose it, and therefore it's likely that the government, in its assessment of whether you meet the statutory conditions, did not make a mistake. Because people who wanted to say otherwise got an opportunity to do it and did not, right? And why would you want to go through opposition? Well, because it's easier. It's much easier to come in there, right? And generally, there's not even a hearing. You just send it in writing, right? Then if the government, the registrar, the administrative person who applies the law, who is, someone who's delegated power by the government, if the registrar thinks that, what you're saying is true in your opposition statement, then they can hold a hearing. And that's generally going to be a lot cheaper because it's an administrative hearing. But more importantly, right, because your trademark is not registered yet, you have the burden. And so it's not the person who says this is not legit who has to prove that it's not, right? They have to send in their opposition. The government reads it. Then the government can reject it, right? So they have to be somewhat convincing. But once the government doesn't reject it, decides to hold a hearing, it's not the person who says it's not legit who has to prove that. On the contrary, it is the person who's trying to register the trademark who has the burden to show that they do meet the statutory conditions. And it makes sense, right? Because you don't have a right yet. You haven't been registered. And so they're not taking away your rights, right, which would require proof, right? They're merely assessing whether they should give you that right in the first place. And therefore, in that situation, it is you, as the person trying to register your trademark, who needs to prove that you meet the conditions. So for the person opposing it, it's easier because, it's a simpler hearing, right? It's held by the governments. The costs are going to be much lower than going to court. And more importantly, right, you don't have the burden. as the person opposing registration, the party getting their trademark does. We'll see shortly that once it's registered, it's the opposite. And so as I said, even if there is no opposition, someone can come in later and say this was not registered properly. This is a distinction. So they're not saying, right, the continued conditions of existence are not met, right, such as they're no longer using it. That's a condition to expunge, to remove the trademark from the registry. That's one thing. The other thing is they can come in and say, not this is no longer legit, but this was never legit. When you registered it, you did not meet the conditions, should have never been registered. As we said, that's something you can do, right, as a person trying to oppose the trademark. In that case, once it is registered, the person opposing it is going to have the burden of proof. And therefore, it's less convenient for them, right? Because, you know, ostensibly, first, it's more expensive because you go to a real court. And second, right, you're less likely to win because when there's a doubt, right, the doubt is going to tilt in favor of the person who does not have the burden of proof. And so if there's a doubt, they're going to let it in the registry, whereas in the opposition procedure that we just discussed, it is the opposite. So that's what the book refers to when it says that that it's a more cost-effective way. They don't say why, that's why. Second things in those various pages of the book, right, are ownership and what we'll call assignment. That might not be, you know, the words that the book uses all the time, but we'll try to be consistent because you'll recall under the other areas of intellectual property law that we discussed already, most predominantly copyright, I called it assignment. So we'll try to be consistent. They call it transfer licensing. You know, again, it's really an expression of what I said. Once you have a right, you generally can do whatever you want with it. You can transfer it forever, not forever, right? In whole, in part, for free, for money. You can rent it or transfer it, whatever it is, it's your right. And so what they call transfer and licensing, right? A transfer is you give it to someone forever. A license generally means a lot of things, but generally is you rent it to someone. And so you let someone do something with it, generally, you know, so you say, to be more specific, you rent your logo, right? But you still own it. That's the difference. You haven't transferred it, you've just rented it. That's a license. And generally, they can only do whatever you said they could do. Generally, but not necessarily, the license, the renting, is not for all of your rights. It's usually for a specific one or number of rights. And obviously what you get in return, typically money, right? Money in the form of a revenue stream, as opposed to money in the lump sum if you're transferring it forever. So, ownership, right? Well, as we said, unlike everything else we're going to see under intellectual property law, you can have a trademark forever, at least theoretically. As we said, industrial designs expire, right, after less than the period for protection of copyright. We said copyright expires after life of the author plus several decades, right? The rule varies depending on the entity from which the copyrighted work emanates, but the result is the same, right? It expires eventually, generally before 100 years, right? Patents, as we'll see, have an even shorter period that they're protected for. This is different, right? This is unique. You can have a registered trademark forever. There's no lifetime bar. There's no life plus 50 years. There's no overall limit. It can be forever, but you have to register it every 10 years. Used to be 15, now is 10, right? Or with the 2014 amendments, to be more precise, is 10. So you can have it forever, but you have to come in every 10 years and renew your registration. Otherwise it's expired and it's too late and you lose it. So ownership, right, we'll say forever, right, but you have to renew every 10 years. Otherwise, your forever ends. And you're mentioned this issue that I've discussed already of intellectual property is property, right? This is the most, the thing that we've looked at that looks the most like an asset, right? Your logo, you can do whatever you want with it. You can sell it, you can assign it, as we said, and, right, one of the issues is, we won't go over it again, I just want you to recall, is that you can transfer it to a third party, right? And so let's imagine this, right? You have a logo on a chocolate bar. Well, you own your logo, so you can do whatever you want with it. You can sell it to someone and then, make money with it. And in that way, it's clear that it's an asset, right? It's a thing with a value of its own that you can convert into money by selling it to someone else on its own. So as I said earlier, obviously if you sell your whole chocolate bar company and the person gets the logo with it, ostensibly they're going to keep using it on chocolate bars. So it won't lose its distinctiveness or use. Under the regime, right, under Section 50, you can sell just the logo. So you can sell just the logo but not the chocolate bar company. And that's allowed. But there's a but, of course, and the but is that you still have to meet the conditions. And so obviously if you sell the logo to a company without the chocolate bars or without the whole company, then maybe over time it will lose its distinctiveness or it won't be used anymore, and therefore, again, since these are continuing conditions, someone could come in and have it removed from the registry because you have to meet these conditions continually, and if you don't, there's this process we briefly discussed called expungement, whereby someone can come in and have it removed from the registry because it no longer meets the conditions. And you're given the procedure. So sections 56 and 57, again the numbers are not important, are going to give you the grounds for opposition after it's registered. So the opposition we discussed is while the trademark owner, the future trademark owner, is trying to get their trademark registered, there's an opposition procedure that's provided for under Section 38 of the Act. As I said, right, that doesn't prevent people from coming in later on and opposing your trademark. That's under Sections 56 and 57, right? And there are two things that we discussed, right? One of them is they can come in and say this was improperly registered. This was never legit, doesn't mean the conditions, I want it removed. Or they can do an expungement. They can come in and say, right, this was properly registered, but as of today, no longer meets the continuing conditions of use and or distinctiveness, and therefore, we want it removed. Very different, reasons, very different, somewhat different procedures, but the result is the same, right? The result is that the trademark is removed from the registry, and depending on the procedure, the way it's removed might change. So if you say it's no longer used, right, it's removed as of then. So the person had a right for whatever period until they stopped using it. So let's say, I registered it in 2017. And now in 2020, someone comes in and says, hey, Phil's no longer using his trademark, let's remove it. The government says yes, right? My trademark is removed from the registry. So as of then, as of 2020, I no longer have a registered trademark. But for the period from 2017 to 2020, right, it was properly registered and used. And so I still had it then. So I could still sue someone for infringement for that period, right? It's not that it was never valid, it's just that it no longer is valid. And for that period it was, I had the right, and I can sue people as a result, right? If the person's claiming that it was never legit, then it's removed retroactively. So if they're saying in 2017, you got your registered trademark, but you never met the conditions, the government should never have given you your trademark, and obviously it's canceled from 2017. So I never had it retroactively, and therefore I can't sue someone for whatever period between 2017 and 2020, right, where I had a registered trademark, because even though I had it, as has now been proven, it was not valid. It did not meet the conditions, and so it was wrongly registered, and therefore I lose it. And as I said, of course, maybe bears repeating one more time, in the case of someone saying it was never legit, after it's registered, they have the burden. So there's a presumption that my trademark is valid. And the person who says it's not now has the burden to prove that it's not, unlike in the opposition that happened before registration, where the burden was the other way. Then you have a very short section on the concept of confusion, right? And we looked at this already. Confusion is, right, this broad idea. Because again, if I have a chocolate bar, right, let's say I have a registered trademark in the word Snickers, because that's a distinctive word, right? It's acquired distinctiveness and goodwill. I'm using it on my chocolate bars actively. I have a trademark on that. It's registered, right? Well, from then, right, obviously if someone uses Snickers on their own chocolate bar, that is clearly, trademark infringement. Because, they took the exact same thing. It's not complicated. But as we said, trademark law has to provide for much more nuanced copying, unlike other areas of intellectual property law. So we have to account for, someone removing a letter, or someone using an entirely different word, but with the same font such that it's confusing. Or someone removing, just one letter, but then, it still sounds the same. Or someone having different letters that sound the same. Anyway, you get the idea, right? What matters is the result. And if the result, when compared, is confusing to the customer, right? So kind of looks like my registered trademark, and therefore could confuse customers into buying the wrong thing, that's trademark infringement. Confusion is this concept that we use to cover a broad range of things. So it's not just a matter of saying someone copied my logo verbatim or my trade name verbatim. It's obviously wrong. But it's also someone creating something different that is, and the standard is, confusing. That is similar enough such that it induces customers into buying my thing wrongfully, and therefore it should be trademark infringement. And that's what the concept of confusion is there for. And there are two ways, right, two things about confusion, right? So as I said, right, it can be confusion with a registered trademark. So when you try to get registration, right, you come in, and as we said, the government looks at whether, you meet the conditions. Well, one of these conditions is that it cannot be confusing with an existing trademark. As we said, the existing registered trademark has priority. And so you compare it with all the registered trademark in the registry, and you look at whether what you're trying to register is confusing with one of those. If it is, it cannot be registered. So the time of registration, it has to be not confusing with a registered trademark. The second thing, right, can be in the use. So it might well be that what the competitor is not always confusing. For instance, as we said, if I start the Snickers restaurant, then it's the same name, right? But it might not be confusing. And why is that? Because, it's a restaurant versus a chocolate bar. And people might not assume, right? I'm presuming they won't assume that, Snickers, the company that's made only chocolate bars forever, just started a restaurant, and therefore customers are going to think, ooh, this is made by Snickers, I should go in. That would be inducing customers into wrongly buying my product. But in fact, it's fair to assume that a restaurant is pretty different from a chocolate bar, even though they're both food, and therefore customers would likely not be confused. And in that case, there is no unfair competition, right? The restaurant is not taking advantage of Snickers' name to get business because it's in a different industry and customers aren't dumb and likely will not think that, the restaurant has anything to do with the chocolate bar. And therefore, right, the use is determinative there. And so the name of my restaurant is in itself confusing with a registered trademark. But, right, the use I'm making of it is relevant. And the opposite is true, right? You can have something that is not similar, that bears confusion when you're using it, right? So typically, something that is similar to Snickers, right, the likelihood that it will confuse a customer increases when it's put on something close to a chocolate bar. Because that's what Snickers is known for, and therefore customers might be more likely to be confused than if it's on something else, like a restaurant or a hotel. And so, not only is it illegal to have a trademark that is confusing with a registered trademark, it's also confusing to use a registered trademark, or anything else really, that is, because of its use, confusing to customers with a registered trademark. And that's in section 6, right, which basically sets out the confusion requirement in greater detail. And to illustrate that, we have the Messier case, right, which is pretty interesting, basically very similar to what I just told you about, right? We have this guy who comes in and wants to create, wants to register the trademark for possum lodges. So the guy is going to sell basically tents, right, like cabins, tents, that kind of thing. And he's going to call them possum lodges. And he's going to put the name on them with the intent that, right, customers are going to buy them because of that, right? Customers are going to want not just a tent, but a possum lodge, and it will be distinctive and will be, a way to build business and, stand out in the marketplace. And so, what does he do? He goes to the registry and tries to get a trademark on that, such that he'll be able to prevent everyone else from using it. And as we said, as these things are self-fulfilling to some extent, it's going to help him, because if he prevents everyone else from, using anything similar, it's going to help him be distinctive, because he'll sue everyone who, prevents him from being distinctive, as we said. And then what happens, right? Well, you have a company with a television show. And in the television show, right, the characters are in a lodge that is called the Possum Lodge. And so the court has to decide whether the trademark on the tents that the guy is trying to register is confusing with that existing registered trademark, right? We're here in the analysis and here, right? Have to assess before registration whether it's confusing. And how'd you do that? By comparing with existing registered trademarks. And who has the burden? As we said, the person trying to get registration has to prove that they're not confusing with another trademark, in addition to proving that they're distinctive and being used. And the court applies a bunch of criteria, which are from Section 6, which we just mentioned, for confusion. You don't have to remember the criteria, and like most of the tests, quote unquote, that we've seen, they're not determinative, right? So they're really examples of things that are helpful to consider. And so, you don't need 2 out of 3 or 5 out of 5. And you can consider other things or some of the things that are listed or a combination or whatever. They're just, things that are helpful, right? They're hints that are helpful in your analysis that is overall circumstantial. And so your analysis is going to depend on the specific circumstances, which might involve these characteristics because, the court put them there for that reason, and then the government did as well, but might also involve other things. And the court applies this test, right, and says, quite interestingly, of course, that the guy's proposed trademark is more distinctive because the guy's only making tents and clothes, whereas the other company, which is, again, as a registered trademark, has existed for a long time, does a range of things. They do television, licensing, product management, and therefore it's less distinctive, right? It's less distinctive because they don't use their trademark on one thing, and then, people know it for that, and therefore it's distinctive. Instead, they do a range of things with their trademark, and therefore it's less distinctive. And so that weighs in favor of the television company, which in the end is going to lose. Which goes to show you, again, that the various parts of the test aren't determinative, right? In fact, one of the indices, right, one of the hints of confusion might weigh in favor of the other party. That doesn't prevent you from ruling in favor of the other party, right? Then the court says, right, the extent to which each trademark has become known. And of course, that's the big part, right? They say, well, it's very well known, right? They've had it on television forever. Millions of people have watched it. It's very well known in Canada. The trademark of the Possum Lodge is used on the television show. And therefore, they win on that criteria. It's much more well known, right? It's been used for a longer time. That's another hint. And, right, so therefore, again, like now we weigh in favor of the television company. So even though they're less distinctive, right, they've used it for so long and are so well known, right, that they get favor under the test, right, under the comparison for confusion purposes. And then looks at the nature of the goods. And that's important, right? It's basically what I said. A restaurant is not confusing because even if it's the same name as the Snickers bar, it's a different area, right? It's a different industry, and therefore it's not likely that customers are going to be confused, right? Here, you'd think in the first place that this is one of those cases because you're comparing a television show and essentially a tent company. And these things are pretty different, right? Usually these are not similar industries. But, right, it's not so true here because in the television show, the whole television show is about the characters being in a lodge, which is called the Possum Lodge, which is what the person making tents is trying to register. And therefore, even though they're in different industries, a customer, right, the court calls it a paragraph 24, a Canadian who has an imperfect recollection of the television show might very well think that they're now making tents and will buy it for that reason. Either because, right, the court doesn't say the first thing explicitly, right? Either because the customer thinks it's similar. So even though it's a television show versus a tent, since the television show was about a tent, the customer might assume that the same people are now making tents to diversify their business. And to the extent that they assume that, right, and that it's not true, that it's the other guy making the tent, customers are going to be misled. It's confusion. Second thing is, right, what the court calls imperfect recollection. So if the customer doesn't really recall where they saw the possum lodge, right, doesn't recall that it's from that television show that they watched, they just remember that Possum Lodge is something nice, right? They remember that it's they had so much fun watching the television show, but don't remember where it came from, but it just, evokes a sense of sudden happiness. Well, that imperfect recollection leads them to have a positive feeling about the word Possum Lodge, and as a result, go buy the tent. The tent, again, which is made by the guy, not the company who made the television show, and as a result, that is confusing. And so the case is very interesting because you're applying the criteria from Section 6 to assess confusion, which you don't have to remember because they're part of a contextual analysis. And we saw in that case, in fact, that one of the criteria weighed in favor of the other party, but nonetheless, because of the other ones, they did not rule in their favor. It shows you it's contextual. It's not conjunctive. It's not you have to meet all of them or else, right? The conditions of a trademark are conversely conjunctive. It has to be distinctive and used and not confusing. That's different. They're hints. In a contextual analysis, contextual means you're looking at everything together, and there are no hard and fast rules as to how you do that. You look at the hints, you look at the law, you look at the criteria that were listed by the courts, and you make a reasoned decision in applying the concept because we think that that's the best way to assess confusion instead of making a conjunctive test. The other thing the case shows you is that this is a contextual analysis in terms of what it means to use a trademark in a confusing manner. And like I said, it depends on everything. A restaurant with the exact same name as the Snickers bar may not be confusing at all because the industry matters, not just the name. Conversely, a chocolate bar with a substantially different name, like Knickers or Fnickers, even though the name's more different, the industry is the same, and that might be confusing because both count and it's a contextual analysis. And here you saw the general rule I gave you, which is if the industries are completely different, it's not likely to be confusing for the reasons I said, because the customer is not going to assume it's the same company, because Snickers doesn't suddenly start making tents, for instance, right? Well, that depends, because in that case, it was a television show and a tent, but the television show was essentially about a tent, and therefore, even though it's different industry, it was likely to be confusing.